Puerto Rico has a unique late fee framework shaped by its civil law legal system, derived from Spanish law, and its status as a U.S. territory. Unlike the 50 states, which operate under a common law system, Puerto Rico's legal framework is based on the Puerto Rico Civil Code, which treats leases as contracts governed by specific civil code provisions. If you're a landlord or tenant in Puerto Rico, understanding how the civil law approach affects late fee enforcement is important, because the legal reasoning differs from the mainland. Let's start with the basics. Puerto Rico does not have a specific statute that caps late fees at a defined dollar amount or percentage. The late fee amount is governed by the lease terms and the Civil Code's general contract principles. Under Puerto Rico's Civil Code, contractual provisions, including late fee clauses, are enforceable as long as they don't violate public policy, morality, or mandatory legal provisions. However, the Civil Code's general principles do impose limits. Under Puerto Rico's contract law framework, a clause that functions as an excessive penalty, a clausula penal, can be modified by a court. Puerto Rico Civil Code Article 2005 gives courts the authority to reduce penalty clauses that are manifestly unreasonable or disproportionate to the actual damages suffered. This means a late fee that grossly exceeds the landlord's actual costs from the late payment can be reduced by a court, even if the tenant agreed to it in the lease. Puerto Rico does not mandate a specific grace period by statute. The lease governs when the late fee triggers. If the lease says rent is due on the first and the late fee applies on the second, that's enforceable. However, practical custom in Puerto Rico generally includes a grace period of 3 to 5 days, and most institutional landlords and property management companies provide at least a short grace period as standard practice. What's reasonable in Puerto Rico? The analysis follows civil law principles. The fee must bear a reasonable relationship to the landlord's actual damages. Administrative costs, follow-up communication, bank processing fees, and the time value of money are all legitimate components. Industry standards suggest that a flat fee of $25 to $50 or a percentage-based fee of 5 to 10% of the monthly rent is generally defensible in Puerto Rico's market. Puerto Rico's economic conditions are an important factor. The territory has experienced significant economic challenges, including the PROMESA fiscal oversight process, population decline, and ongoing recovery from natural disasters. Average household incomes are substantially lower than the mainland average, and many tenants live on fixed or limited incomes. A late fee that might be reasonable in a high-income mainland market can be disproportionate in Puerto Rico's economic context. The lease must clearly state the late fee terms. Under civil law principles, contractual obligations must be clearly defined and agreed upon by both parties. A late fee provision should specify the rent due date, any grace period, the exact fee amount or formula when the fee triggers, and whether additional charges apply for continued non-payment. Ambiguous provisions are interpreted against the party who drafted the contract, which in a lease is almost always the landlord. Compounding late fees in Puerto Rico must satisfy the Civil Code's general principles. A single one-time fee is straightforward and less likely to be challenged. A daily or weekly compounding structure that could accumulate to a disproportionate amount faces the risk of judicial modification under Article 2005's Penalty Reduction Authority. The safest approach is a single reasonable fee per late payment. The interaction between late fees and the eviction process in Puerto Rico follows the territory's civil law framework. Puerto Rico's eviction process, known as desahucio, is governed by specific procedural rules. When pursuing eviction for non-payment, the amount demanded must be accurate. Whether late fees are included in the demand depends on how the lease characterizes them. If defined as additional rent, they can be included. Puerto Rico's eviction process has historically been slower than many mainland states, which means late fees can accumulate over a longer period before the eviction is resolved. During this extended timeline, the total late fee accumulation must still remain reasonable, a factor courts consider when evaluating the landlord's claim. Puerto Rico does not have a specific territorial statute imposing a uniform security deposit cap or return timeline comparable to what exists in many states. The terms are governed by the lease and civil code principles. When a tenant vacates with unpaid late fees, the landlord can deduct the fees from the deposit if the lease authorizes the deduction, but the fees must be reasonable under the civil code framework. For tenants receiving housing choice voucher assistance, administered in Puerto Rico through the Puerto Rico Public Housing Administration, landlords should not charge late fees when the authority's portion is delayed due to processing. Puerto Rico's voucher program serves a large population, and penalizing tenants for the authority's administrative delays is both unfair and potentially actionable. Puerto Rico's hurricane risk creates specific considerations. Major storms, including Hurricane Maria in 2017 and subsequent storms, have disrupted the territory's economy, infrastructure, and many tenants' ability to pay rent on time. In the aftermath of a major storm, aggressive late fee enforcement against tenants dealing with displacement, property damage, power outages, and economic disruption is both legally risky and practically unproductive. Some landlords voluntarily suspend late fees during declared disaster periods, which is a recommended best practice. The FEMA disaster assistance process that follows major storms can affect payment timing. Tenants waiting for FEMA payments or insurance proceeds may experience temporary cash flow disruptions. Landlords who work with tenants during these periods, rather than aggressively enforcing fees, generally achieve better long-term outcomes. Puerto Rico's population decline has affected the rental market across the territory. Hundreds of thousands of residents have migrated to the mainland over the past 2 decades, reducing demand in many communities. In a softening market, losing a tenant over a late fee dispute costs more than the fee is worth. Landlords should evaluate whether aggressive fee enforcement serves their business interests in their specific market. From a practical standpoint, Puerto Rico's rental market has distinct regional dynamics that affect late fee practices. The San Juan Metro, including Bayamón, Carolina, Guaynabo, Cataño, and Trujillo Alto, contains the majority of the territory's rental activity. The economy is driven by government, healthcare, financial services, pharmaceuticals, tourism, and the Act 60 tax incentive economy. San Juan's market is the most active and competitive in Puerto Rico. The Act 60 market segment, mainland entrepreneurs and remote workers who relocated for tax benefits, represents a growing portion of the tenant population in certain San Juan neighborhoods. These tenants typically have strong financial profiles and pay reliably. Late fee enforcement is rarely needed for this demographic. Condado, Ocean Park, and Isla Verde have attracted significant Act 60 demand. Ponce, Mayagüez, Aguadilla, and other cities outside the San Juan Metro have more affordable and softer markets. Tenant populations in these communities often include more lower-income households, and late payment rates may be higher. Late fee amounts should reflect the local economic conditions. A fee that's reasonable in San Juan may be disproportionate in a smaller community with lower rents and lower incomes. Puerto Rico's pharmaceutical industry, concentrated in communities like Barceloneta, Juncos, and Humacao, employs a workforce that generally has stable income and reliable payment patterns. Late fee enforcement in pharmaceutical company towns is typically routine. One best practice for Puerto Rico landlords: draft your late fee provision in both Spanish and English if you serve both local and mainland tenants. Clarity is essential under civil law principles, and a bilingual provision ensures that every tenant understands the terms regardless of their primary language. Another best practice: set your late fee at a level that reflects Puerto Rico's economic reality. Average incomes are lower, economic challenges are real, and courts have the authority to reduce excessive penalties under Article 2005. A fee of 5 to 8% of the monthly rent is generally defensible. A fee approaching 15 or 20% invites judicial reduction. A third best practice: have a disaster contingency plan for late fees. Puerto Rico's vulnerability to hurricanes, earthquakes, and other natural events means that disruptions are a matter of when, not if. Having a documented policy for temporarily suspending late fees during declared disasters demonstrates good faith, reduces legal risk, and preserves the landlord-tenant relationship through difficult periods. For the complete guide to Puerto Rico late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.